You may be seated. Calling 1-81950, State of Michigan versus Ariana Griffin. Your appearances, counsel?
Moving on, may please the most honorable court, number 8054 on behalf of the people.
And for your honor, Neighborhood Defender Service of Detroit, Jonathan Portis, E7894 on behalf of Mrs. Ariana Griffin, who's approaching pregnant.
Thank you. You may be seated. Do we have any preliminary matters to discuss before we start the exam?
All the people who for declaration of all witnesses are testified now.
Beth will join in that request. The only other preliminary matter I can think of is that I believe we have a small discovery issue. I've been in discussions with people with regards to a possible interrogation of that. Mr. Andrew delivered electronic discovery to me, but unfortunately in that discovery did not include the interrogation video. I expect that to be subject of perhaps the OIC's testimony today, assuming they're here, and I believe it's necessary to do. We can address that at the appropriate time, but I did want to highlight that to attention that we are missing that critical piece of information that may be the subject of testimony.
Will that keep you from being able to proceed this morning?
Without the officer testimony, I don't believe it would be a hindrance. I think we can leave the victim's testimony.
Yeah, with respect to the complaining witness, I am prepared to proceed. It's just if the officer is going to testify with respect to an interrogation, then I may be making a motion to exclude any testimony regarding the interrogation without production of the tape.
Okay.
Violation of discovery.
Your Honor, the fact also remains is that I did send this report about 10 to 13 digital discs via evidence.com about a week and a half later. I did send the interrogation to a bunch of the neighborhood meetings. So the OIC emailed it to me. I immediately forwarded it to every email. And yes, I'm not sure why they don't have everything else.
And Judge, unfortunately, I can't comment specifically on what the law clerks at my office did. I do know that I do have the larger package of discovery materials. I did not see the interrogation. So it could be a clerical error. I would ask Mr. Andrew to check his emails to verify that it was actually sent address when we decided.
So it could be a clerical issue and it could be an issue, but not really if the OIC doesn't testify to the contents of the interrogation.
Yes.
Okay. I said it succinctly, but I'm hoping that I covered what you both meant to cover.
Yeah, absolutely. I mean, however, UIC doesn't appear today that would be the majority of his testimony with interrogation defendant. But again, for probable cause purposes, I believe the victim could make.
Okay.
We'll see where we get there.
We'll see where we get then. The only other thing that I'd like to address, you can have a seat. The only other thing I'd like to address is this is my first live preliminary exam. So because we have these COVID issues, I just wanted to go out on the record and say, I'm not wearing a mask because I'm distanced from my staff. And when witnesses start coming up, I'm going to say to you all, once you're in place, if you're comfortable unmasking for purposes of being able to question and hear and be heard, I understand. If you'd rather stay masked, I understand as well. We're trying to be safe. We're trying to make sure that we're doing everything appropriately. If anyone's uncomfortable during any of the proceedings, please say something and we'll make the adjustments, either put people further apart, or if you prefer my staff and myself to be masked, we can do that. We're just trying to make sure that everyone's comfortable as we proceed.
Yeah. And just for the record, we'll be using this.
We'll be using the witness box.
Understood.
Any other preliminary matters?
Oh, man.
Mr. Andrew, please call your first witness.
Thank you, Your Honor. Your Honor, this time of people call Mr. Martel Johnson.
Mr. Johnson, I'm going to have you stop first right here and spell your name. Come up a little closer. Spell your first and last name for my recorder. You're going to come up this little ramp. Be careful. It's a little bit of an incline. And you can have a seat right here. Oh, I'm sorry. Before you sit, You swear the firm testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. May I have a seat? Mr. Andrew.
Yes, Your Honor. Sir, can you please state your name for the record? And Mr. Johnson, I want to take you back to the date, March 2018. You recall being at the location of 15762 Harrison Road in Romulus? That's in the county of Wayne. At that address. What is located at that address?
Oh, my mom.
Now, can you tell us what, if anything, occurred on that date and at that location that brings you to court here today?
I flew up to my mama's house.
You say you pulled up to her house.
Yeah.
What were you in?
Black car.
This is and this vehicle belonged to you? Okay. What happened when you pulled up to your mom's house?
As soon as I pulled up, you're slicing my neck.
What, you had passengers in your vehicle. At what point did you pick up the passengers?
Before I got
Okay, so earlier in the, what day was it?
it was late at night.
Sometime in the evening. You picked up passengers. Okay, how many passengers did you pick up? Do you recall? It looked like. Okay, now you're saying you pulled up to your mother's house. What happened? Let's take a step.
As soon as I pulled up,
You pulled up, you stopped the vehicle?
as soon as I stopped, you're behind the seat. That's my neck. And I jumped out.
You said she slit your neck. With what?
Looked like a kitchen knife.
Okay, now the girl you said that was in this night, you see her in the courtroom?
Yes.
And can you point to the location that she's seated? Tell me something she's wearing.
My white Tommy Hill.
Your Honor, I'm going to object to the identification. I think it's unduly suggestive. Two, I suppose I can cover that across, as this witness was not previously able to identify my client.
Yeah, he wasn't able to identify the six-pack photo that was shown back in 2018. However, nothing indicates to me that what happened to him is not something we soon forget or we can run the counsel thing for that.
Objection overruled.
Right, actually, I want to stand up. I want you to take a good look. Tell me if you recognize anyone here.
Yes.
Where are they? And where do you recognize her from? Okay, and what part did you play in that event? All right, Your Honor, for the record, the witness has just identified the defendant.
Identified.
Okay, so let's get back to you pulled up to your aunt's house and she pulls out a knife.
How did she cut my neck?
Did you see the knife?
After my neck.
Where on your neck was where you cut?
All the way right here.
Well, let the record reflect that the witness is placing his index finger off his throat and moving in a horizontal fashion.
So reflected.
And you were able to see the knife afterward. What did it look like?
Like a kitchen knife.
How big was it?
Pretty big, perfect.
Let the record reflect that the witness is holding up about 9 to 10 inches in length.
I'd estimate closer to 7 to 8 foot thick.
Thank you.
I can get it. Thank you. All right, so tell me, what did she do with that knife?
It's my neck.
Now, when you say she said it, what did you do? Did you press again? Like, did you feel pressure? What did you feel? Tell me what you felt.
As soon as my neck got slit, I just look. Joe, wow.
All right. At any point, did Becky see the laceration? What did it look like?
Blood inside of my neck.
Right. Just a moment, Your Honor. All right, so you jumped out of the vehicle, you're gushing blood at this point. What happened next?
I ran to the window, tried to get something like that, open the door. My brother got to the window. He jumped out the window. He jumped out the window and took off in my car.
Did you give them permission to take your vehicle?
Huh?
Did you give them permission to take your vehicle?
No.
So let me ask you this, when you felt the knife against your throat, what was running through your mind?
Yeah. Everything.
So you thought you could kill you? I have no further questions at this time, Your Honor.
You indicated that you could recognize and identify the person that cut you, right? But you were presented with a series of photographs back in 2018, is that correct?
Yeah.
And the officer in charge of the case at that time presented you with those photographs, correct? And at that time, you indicated that you did not recognize anybody in those photographs, right? So in 2018, you were given the opportunity to identify the person that attacked you, and you couldn't do it.
No, I told them it was few. It's just a couple people left them in the paper. I told them that.
But you couldn't be sure who it was.
No, but when I see them face to face, I will know.
2 years have gone by. And now you can make the identification.
I could have made the identification if I seen her in person back then.
But the fact of the matter is that you weren't able to pick out Ms. Griffin's photo back in 2018,
Yeah,
correct?
because it was a black and white piece of paper when.
Sir, just answer my question. Is it true that you were not able to pick out Ms. Griffin's photo back in 2018?
No.
It's not true.
That was true.
Now, you said that you had these 2 females in your car. How did you come to encounter these females like that?
From Facebook, I hit her up, asked what she was doing. And,
When you say her, who are you referring to?
the friend,
Okay, there was this other person involved, it was Kia, right?
Yeah.
Now, you coordinated with Kia for a sexual encounter, is that right?
just to hang out and they was talking about sex, threesomes and stuff.
Have you ever met this girl before?
Yeah.
Okay, where did you meet her?
We hung out before.
Where did you meet
And it's,
her? Okay, and had you met her on Facebook previously?
no.
Okay, so how did you obtain her contact information?
That's how I got it from Facebook.
So how did you coordinate your previous encounter with Kia?
Facebook.
Okay, how did you come to get Kia's Facebook information in the first place?
Gave it to me. When I met her.
Okay, where did you meet her?
Detroit.
Where in Detroit?
A long time ago, before this, like a year or two before this.
You don't remember where you first met Kia? What you're saying. Now, had you ever met the second person that you transported?
No.
So that day was the very first time you ever encountered them. And Kia didn't give you that person's name either, right?
Nope.
Nor did Kia show you a photograph of that person, correct?
Nope. Yes, she did. Yes, she did.
So she's talking about threesomes and you're gonna go pick her up. That's what you're saying, right?
Yep.
What else were you gonna do then? So you were gonna pick them up, you're gonna go back to your mom's house and you were gonna have a threesome?
That was going to happen at the time, yes.
Okay, was your mom home?
No.
Okay, your brother's? Because he's the one that jumped out the window, right? What's your brother's name?
Glad you know Harvey.
Now, when the vehicle took off, this help you understand, is a vehicle tinted windows?
Back tinted the front.
Okay, are the sides tinted at all?
Back tinted the front.
I'm just asking, are the side windows tinted? And what orientation was the vehicle relative to the house? So you said you get out the car, your brother comes jumping out the window, right? Which direction is the vehicle pointing? Toward the house, away from the house?
House and park.
The house is on the side, you're gesturing to the left, as if you're correct.
The house facing this way, her facing that.
So the witness is gesturing towards himself in the orientation of the house and to his left with respect to the car. So if I'm looking out the front door of your house, the vehicle was pointed to the right, correct?
Yeah.
Or do I have that backwards to the left?
This way.
Okay, so the vehicle is basically sideways towards the house. Is it parked on the street? Okay. Would it be fair to say that at that time you were focusing on getting medical attention, right? All you're concerned about is making sure that you're not going to die, right? You're not paying attention to who's in the car, to what's going on at that point, right?
When I jumped out, I looked and did it and face.
But I'm saying, what I'm asking you is, your primary concern was not focusing on the vehicle, right? At
No,
that point, you're just focusing on staying alive, right? Now, I assume that your brother called 911, is that right? So she was home too. How many other people were in the house that night?
my sister, my two brothers,
What's the other brother's name? Davon? What's his last name? Okay. Was there anybody else home? And did they transport you to the hospital, or did you wait for an ambulance? You would agree with me that you never saw the person who wrote after the incident, correct?
I seen it when they got in.
After the day that this happened, you never saw the incident, right? Did you ultimately get the vehicle back? How long did that take?
Kirby. One,
Was anything damaged on the vehicle?
yeah, the curb was damaged, I had to get fixed and all my stuff.
What stuff did you have in there?
Clothes, shoes, glasses,
You wear glasses? What kind of glasses?
designer glasses.
Yes, sir.
I have no further questions this time. Thank you.
Thank you. Mr. Andrew, anything further?
Briefly, Your Honor. You have two females in the vehicle with you, right? Where were they sitting?
One passenger seat and one director behind.
Who was in the passenger seat?
Apartment.
Okay, who was in the back seat behind? And the assault came from. Again, you never at any point told these girls that they could take your car. I have no further questions, Your Honor.
Thank you. Mr. Johnson, thank you. You can step down. Do you have any other witnesses, Mr. Andrew?
I do not, Your Honor.
No, this is for the defense.
That's it.
Your Honor, the other witness is going to be the officer in charge who's going to testify to the interrogation and statements made by the defendant. And he'd be here.
If perhaps we should exclude the complaint, this is probably we're gonna conduct arguments.
Is that where we're going right now? We're going to argument?
I'm not sure if that's where we're going. If we're going there, then perhaps it's better if we go talk about
Mr. Andrew?
Your Honor, the people would be ready for argument. There is no other witness.
Thank you. Mr. Johnson, you're all set. Thank you for coming in this morning.
It was good.
I'm ready when you are.
Your Honor, this time the people who hand over his charge as a count one carjacking. We heard testimony from the witness, Mr. Johnson, that he was in fact driving his vehicle, had two passengers in the vehicle. And at one point in the evening, the defendant pulled out a knife, placed it against his throat and sliced his throat to the point that tissue coming out of it and blood was gushing. We would submit that's the force used for the vehicle. And at some point afterwards, after he jumped out of the vehicle, she and her accomplice took this gentleman's vehicle and drove it away without his permission. So that would, people would submit that that is enough for count 5 and 6, receiving a vehicle and unlawful driving away. Now again, getting back to the laceration that Mr. Johnson suffered on his neck, blood gushing, tissue leak, coming out from inside of his neck. That the people would submit that there was enough force that, if not a quarter inch deeper, 8 inches deeper, this gentleman would not have been here. That is goes to count 2, assault with intent to murder. And now, if your Honor finds that did in fact happen, and you submit that count 3 will also follow with assault with intent to do great bodily harm, less than murder or by speculation. Your Honor, I believe, the people believe that there's enough evidence on the record here for probable cause of information that the defendant did in fact commit the heinous act, and it was in the city of Romulus, County of Wayne. And there should be a bind over as charged and allow a charge of fact to determine if there's any other questions of fact. Thank you.
Thank you, Mr. Andrew. Mr. Hordos.
Yes, Judge. I'll object to the bind over a couple different reasons. First, identification. I'll be picking on from my questioning. Obviously, this is deeply troubling that a witness can be presented with a 6-pack lineup very close in time to the offense, that he cannot identify a photograph of Ms. Griffin at that time, that only 2 years later, perhaps more than 2 years later at this point, almost 3 now, that he's then able to make an in-court identification on a person who's the only available person sitting in the courtroom, who's wearing a mask and jail duty. So it almost sort of goes beyond credibility as to how this complainant can possibly make that identification almost 3 years later through a mask, through obstacles, and with the only one person who's here to be identified. So I think the identification is effective, unduly suggestive, and ultimately the witness laid out all you need to know about his credibility on the witness stand. He didn't lead with the purpose of soliciting these women for sex that night, and ultimately was kind of cagey about it, had to really be drawn out of it. So I think identification there is a little suspect and not satisfying the probable cause standard. With respect to the specific charges, for the vehicle-related charges of carjacking and unlawful driving of a vehicle, the witness did not indicate that my client was in the driver's seat. It didn't indicate I said anything with respect to taking the vehicle, like grab the keys or anything like that. That would indicate that my client was an instrumentality of seizing the vehicle. At best, he's indicated that he said he saw them look them in the face, as they were driving away. I think that was the line that he said, but didn't really get much more specific on that on who was driving the car. I think in order to establish the carjacking, the people would have to pursue an aiding and abetting theory. In order to pursue an aiding and abetting theory, they need to establish that my client did something to assist in the commission of the offense and intended the offense, or that the offense was a natural and probable outgrowth of the offense that my client did intend. So even if the people have established, some type of assaultive offense by virtue of the knife, etc., it does not necessarily follow that the theft of the vehicle was a intended consequence or a natural and probable outgrowth without more evidence, say, grab the key, something to indicate that my client knew that the car was going to be taken or that she intended for it to be. Without more evidence on the record to that particular point, I think both of the vehicle-related charges fall. That would be the carjacking and the unlawful driving away of the vehicle and receiving and concealing stolen property. Specifically with respect to the receiving and concealing stolen property count, as the complaining witness did establish that my client was specifically in control or in possession of the car at any point, I don't see how that one applies, even under that aiding and abetting theory, because how would she do something to assist in the possession or the hiding of the vehicle? We really don't have any evidence on the record about that, or sort of strained argument with respect to the taking of the vehicle. Then, Judge, with respect to the assault with intent to murder, Mr. Andrew anticipated my argument a little bit. We don't have any medical records that indicate what was, whether or not it's, while the witness said something along the lines of "I saw my eyes" or something like that, that did not indicate whether that was fatty tissue. It didn't indicate whether it was life-threatening. How much force was used to make the cut. Without, I think, medical records, we found it really hard to determine that level of force. While I understand that the charges with intent to murder and no injury is necessary for proving the crime, certainly it's instructive to sort of get at the heart of, what was the objective here. And since the witness was not able to, is not a medical expert, was not able to give us all those details, people didn't introduce those details, I think that particular charge is not supported by law. So essentially 3 issues: identification, lack of assistance or agency with respect to the vehicle charges, and then lack of respect to the intent. Thank you, Judge.
Thank you.
With respect to the identification, this does indicate that because he was shown black and white and he was unable to make identification at that time, they indicate that seeing this person once again would be able to identify what you did here in court. Further to carjacking, Your Honor, this is a quintessential carjacking case. She put a knife in his throat, sliced his throat open, and took his car. That's the very definition of a carjacker. With regard to Mr. Hortus and Mr. Johnson able to see his neck. Normally his neck is not bleeding and tissue hanging out of it. But I think he can make an observation, an intelligent observation, to say that it was that deep. And a cut that deep, you can only mean to do one thing. When you're cutting across someone's throat like that, there's only one thing going through your mind: I'm going to kill this person. That's exactly what we have here today. And with that, Your Honor, again, the people would move for bind over as this is a probable cause conference, and it appears that the people have met their burden to a probable cause standard at the very least. And again, any issues of fact should be left up to a trier of fact to determine. And I'll leave it at that, Your Honor. Thank you.
I listened to the arguments of counsel, listened to the witness this morning, and I will grant the people's motion. The defendant will be bound over as previously charged on all counts. The date to appear in circuit court will be, what are we given, 2 weeks out?
In custody, I think.
1 week? Mary Ann's checking the date.
Okay, thank you. In custody.
Thank you. February 8th, 2021. Anything else, Mr. Andrew?
Nothing, people, Your Honor.
Anything else, Mr. Hordos?
Yes, Judge, with respect to bond, I believe that the bond in this case is set at 100,000 cash. Is that correct?
Cash surety 10%.
Judge, I'm asking the court to consider a reduction in the bond. While the court did find that there was probable cause for it can obviously see sort of the bent of this defense, that there's an identification issue going forward to trial. Ms. Griffin ultimately has a vested interest in seeing this case through. That is a viable defense based on identification, not at all certain that conviction based on the evidence that is. Ultimately, she does have a minor child area and lives in the area. She's not a flight risk in that respect. I don't even believe she has the means to travel outside the United States or anywhere that in our region. I believe that based on the length of time that's elapsed in this case, almost 3 years now, there's been no indication that she seems like the reason that this case took so long was because the complaining witness couldn't identify my client. back at the time that the opportunity was given. So in light of these sort of special circumstances, I'm asking the court to consider a bond that Ms. Griffin could actually post. Because right now, the bond that's set at the level that it is essentially equivalent to a refund. That's really not what a cash bail should be. What a cash bail should be to secure the client's appearance and protect the public where a non-cash solution is not an option. I think that there are other conditions that can reasonably secure the safety of the community and the return to court of my client, such as like a GPS tether condition, a house arrest condition. All of those things are more reasonable and more narrowly tailored to that objective than just saying pay $100,000 to get out, which is, essentially a remand for a person. My client has been in custody now for over a month and has no hope of being released with the cash bond. I would ask the court to fashion something that is within her financial means to post, but significant enough to obviously encourage the end that the court wants. And then, of course, a GPS condition, house arrest, whatever conditions the court feels are necessary. But the cash bond being where it's at is just equivalent.
What number do you propose?
I would propose something like a 5,000 cash surety, Judge, something that could be posted by family with a GPS tether condition and again, house arrest. I think those things puts skin in the game and also allows the court to keep an eye on her, to know where she's at, to make sure she's not traveling. I think all of those things would be perfectly adequate.
Anything else?
No, Judge, thank you.
Mr. Andrew?
Your Honor, I understand what Mr. Holder is saying. However, this river is struck with a capital. That he did try to take a man's life, take his vehicle. People believe that the bond is appropriate where it is. However, Your Honor does decide to have mercy on the defendant and lower the bond, ask for GPS to the house arrest at the very least.
Mr. Hordos?
Yes, Judge.
Anything else?
No, Your Honor.
I have heard your arguments, and although I'm sensitive and to Ms. Griffin's position, it is in fact, as counsel said, a capital crime. The allegations, if true, cause some concern. And I understand that she's been in custody for, it looks like about 5 or 6 weeks now. I don't feel comfortable reducing this bond. I'm going to deny your request to change the bond conditions at all. So the current conditions will continue. Anything else this morning?
No, Judge, thank you.
Anything else?
Your Honor.
Thank you very much.
Thank you, Judge. You have a great day. You staff.
You too. Thank you. We're off the record. Thank you.